Have you ever just paused to consider the invisible scaffolding that holds the entire legislative structure of a country together?
It's a fascinating thought experiment, isn't it?
I mean, really think about it. You have hundreds of laws passed across more than a century by completely different governments tackling everything from, I don't know, taxation to corporate governance.
And they all use the same basic words.
Exactly. Words like month, document, or immovable property. But what happens when none of them actually bother to define it? How does the legal world stop itself from just collapsing into, total definitional chaos?
Well, that chaos is the single biggest threat to judicial certainty. And it's precisely what we have systems in place to avoid. The legal system, it just can't afford to constantly reinvent the semantic wheel every single time.
Or relitigate the meaning of a common word.
Right. It needs a shared universal language, a core set of operating instructions that apply across the board year after year, no matter which specific law you're reading.
Okay, let's unpack this. Our mission today is to pull back the curtain on this hidden architecture. We're doing a deep dive into the foundational text of legislative interpretation in India, the General Clauses Act, 1897.
This act is, in essence, the master dictionary. It's the default settings, the operating manual for every central act and regulation that has been passed since it was enacted.
So for you, the learner, this is like a personalized, in-depth masterclass in how statutes actually talk to each other. It's how to unlock the baseline meaning of every law you'll ever read.
And this is truly essential knowledge. Understanding this act is, it's like getting the source code for the entire legal system.
That's a great way to put it.
When we explore this text, we aren't just memorizing definitions, we're exploring the underlying logic of legislative continuity. We're asking why these definitions matter for, judicial application across nearly 130 years of evolving governance.
And why a word chosen way back in 1897 still governs lawmaking today.
Exactly.
So by the end of this deep dive, you'll be able to explain the foundational purpose of this act, know the crucial general definitions, and identify the rules of construction that courts use every single day.
You'll also understand the implied administrative powers that come with orders and rules, and get familiar with those key miscellaneous provisions that, for example, protect against double punishment and ensure legal communication actually works.
We're going to explore this law section by section, like you're getting a custom-tailored legal education.
Let's get into it.
All right, let's start at the very beginning. The genesis of this crucial document. The General Clauses Act of 1897, it wasn't just a sudden creation, was it? It was born out of a real need for consolidation.
That's absolutely correct. It was formally enacted on March 11th, 1897, but it actually superseded two earlier attempts at standardization. There were General Clauses Acts in 1868 and 1887.
So this was the third and final attempt.
Yes, the final unified act. And its purpose was twofold. First, to consolidate and extend the general definitions of common terms, and second, to establish universal principles for statutory interpretation that every other law has to follow.
And the extraordinary power of these general definitions is that they apply to pretty much all central acts and regulations unless, and this is the crucial escape clause, right?
Right. The escape clause is if a specific definition already exists within that particular act, or if the context of that act is repugnant to the GCA definition.
And repugnant just means contradictory or incompatible.
Exactly. It serves as the ultimate default setting. If, say, the Transfer of Property Act is a bit vague about whether a right is property, the GCA steps in to fill that gap.
Which also makes it indispensable for resolving conflicts, especially historical ones.
Particularly the conflict between pre-constitutional laws, those passed before 1950, and our modern post-constitutional laws. It provides that judicial clarity you need on things like commencement and enforcement. It just prevents massive uncertainty.
It really is the legislative glue. Let's break down the four explicit objectives of the Act. They're like the four pillars that rationalize the entire structure.
They really are, and these four pillars represent a masterclass in bureaucratic efficiency. First, the GCA's object is explicitly to shorten the language of central acts.
Okay, so just making laws less wordy.
Precisely. Imagine the immense legislative time wasted and the sheer volume of text if every single act had to define financial year or official gazette or month. The GCA avoids this constant, costly repetition. It makes statutes leaner.
That immediately addresses efficiency. What's the second objective?
The second is about consistency. It aims to provide uniformity of expression.
I see. So a word means the same thing everywhere.
By defining a core set of terms like "ac" or "affidavit," you ensure that whether that term appears in a customs law or an environmental law or a corporate statute, all courts and all citizens start from the exact same universal dictionary. That predictability is vital for the rule of law.
Okay, third, it seems to go beyond just definitions.
Yes. Third, it explicitly establishes convenient rules for the construction or interpretation of central acts. These are the mechanical rules. They determine how you calculate time periods, how you figure out the meaning of subordinate rules, and crucially, how you handle the fallout when one law replaces another. It's the procedure manual.
And the fourth pillar is maybe the most protective one. It's designed to guard against legal slips and oversights. This part is brilliant because it's automatic.
It's a legislative safety net. The GCA automatically imports essential common form clauses into every central act. So if a legislator just forgets to specify, say, what happens to rights accrued under a law that gets repealed,
The GCA steps in.
instantly. This prevents the entire legal system from breaking just because of simple human error or an oversight in drafting.
And the courts have backed this up, right? What's the Supreme Court's definitive view on its purpose?
The case of the Chief Inspector of Mines v. Karamchand Thaipar really settled it. The court stated, very definitively, that the purpose of the GCA is to place all interpretation provisions and legal principles in one single statute to avoid a superfluity of language.
So to avoid repetition.
Exactly. And the core takeaway for every learner has to be this. Whatever the GCA says, whether it's about the meaning of words or legal principles, has to be read into every act to which it applies. You have to assume the GCA is the silent partner in the drafting room of every central act you ever encounter.
So if the GCA is this foundational layer, where does its jurisdiction actually extend? What's the scope of its application?
That's a great question. Although the Act itself doesn't have a modern territorial extent clause, its reach is, implicitly applicable wherever a central act is extended. It applies primarily to central acts from the Indian Parliament and, crucially, to subordinate legislation.
The rules, schemes, and regulations made under those acts.
Correct.
Given its 1897 origin, the historical context must make its application incredibly complex. I mean, it has to cover acts passed under completely different political structures.
It does, and its historical scope is wide. It applies to acts of the Dominion legislature. That's the transitional phase between August 47 and January 50. And it covers acts passed by the Governor General and Council or anyone acting in a legislative capacity before the Constitution.
Which ensures seamless interpretation across different eras of governance.
Precisely. It links the British Raj, the Dominion, and the Republic.
But here's where it gets really interesting for me. The constitutional mandate. The GCA isn't just about interpreting regular statutes. It's so fundamental, it helps interpret the supreme law of the land, the Constitution itself.
That is a colossal point. It just elevates the Act's status enormously. Article 367 of the Constitution explicitly says that, unless the context otherwise requires, the General Clauses Act 1897 shall apply for the interpretation of this Constitution.
So when you're trying to figure out what a constitutional term means, the GCA is the default baseline.
It is, which just underscores how indispensable its rules are to the entire governmental framework.
To really see the GCA in action, let's use that classic property law example, Ananda Behera v. State of Orissa. This is a perfect demonstration of how the GCA solves a problem that other, more specific laws just left open.
It is a great case. The legal problem in Ananda Behera was deceptively simple. Was the right to catch and carry away fish movable property or immovable property?
And the main law, the Transfer of Property Act, didn't have a clear answer.
Not really. It defined immovable property mostly by what it was, not like standing timber or grass, but it didn't explicitly cover a specialized right, like fishing rights, so there was a vacuum.
The court had no specific law to turn to, so they needed a default definition.
And they immediately turned to Section 326 of the GCA. This section defines immovable property inclusively. It says it includes 4 core elements: land, things attached to the earth, things permanently fastened to anything attached to the earth, and critically, benefits to arise out of land.
So the court analyzed the right to catch fish as a profit a prendre. For anyone listening, that's a French legal term. Can you break that down in plain English?
Absolutely. Profit a prendre is simply a legal right to take a part of the soil or the produce of the land that's owned by another person. In this case, the fish were the produce being taken from the land, or, the water body attached to the land.
I see. So because the right to catch fish was a benefit arising out of land, The court used the GCA to define it as immovable property.
It did. The GCA effectively filled a definitional vacuum in the Transfer of Property Act and resolved a complex property dispute using its standardized definition.
That shows its functional brilliance. But we have to note the caveat. Not every single section applies universally to every law ever written, right?
That's vital. The Act itself defines its own internal scope based on timelines. For example, Section 4 only applies to central acts made after January 3, 1868, and regulations made after January 14, 1887. You always have to check the timeline.
But courts do sometimes apply the general principles, even when a section doesn't technically apply.
They do, simply because its rules reflect established jurisprudence and, well, fairness.
And finally, the GCA serves as the ultimate legislative template for other jurisdictions.
Yes. The 1897 Act served as the foundational model for the State General Clauses Acts. And this modeling is essential for ensuring consistency across different jurisdictions. I mean, imagine the chaos if the word month meant different things in different states. The GCA prevents that kind of fragmentation.
Okay, let's shift focus from the GCA itself to the architecture of legislation in general. Before we even get to the core sections of a law, there's the preamble. What is the preamble's exact role, and how much legal weight does it actually carry?
The preamble is the statement of intent. It's the mission statement. It expresses the scope, the object, the purpose. It tells you why the lawmaker wrote the law in the first place.
Like in the Negotiable Instruments Act.
Exactly. It says it's an act to define and amend the law, which defines both its scope and its intent.
But I understand the preamble can't override the actual text of the statute. That seems like a big limitation on its power.
It is a critical limitation. The preamble is an aid to construction. It's not a law in itself. It's used for interpreting the act, but only when there's ambiguity.
So if a word has multiple meanings, you look to the preamble.
Right. Or if a section is unclear. The preamble helps the court figure out the intended meaning. But if the provisions of the act are plain and clear, you cannot use the preamble to modify or contradict them. It discloses the intent, but the substantive sections govern.
That clarifies its role. Before we move on, let's just make sure we're clear on the difference between a bill and an act.
A bill is the initial draft proposal. It's the text that's debated in Parliament. It only becomes an act after it's passed by both houses and gets the mandatory assent of the president.
And once that happens, it's notified in the official gazette.
And becomes law.
Now let's look at the definition clauses within specific acts, usually Section 2 or 3. They're there to avoid repetition, but how do we decide which definition to use? There's a sort of hierarchy, a ladder of meaning.
There is a very clear three-step ladder. Step 1 is always the most specific. You look at the specific act itself. If you're reading the Companies Act, 2013, the definition of company is right there in Section 220. That definition takes absolute precedence. It overrides the GCA.
What if the word isn't defined there? Say, a modern term the original act didn't foresee.
Then you go to Step 2, definitions referred from other statutes. Many modern laws do this. For example, the Companies Act doesn't define security. It specifically cross-references the definition in the Securities Contracts Regulations Act, 1956.
Okay, so first a specific act, then a cross-referenced act. And if it's not in either of those, that's when the GCA steps in.
Exactly. That's the final step, Step 3, where the General Clauses Act becomes the default authority. For instance, the word affidavit in the Companies Act isn't defined there or cross-referenced, so it automatically adopts the meaning from Section 3.3 of the GCA. This hierarchy ensures certainty.
Now let's delve into legal semantics, the absolute crux of interpretation. The difference between means and include. This can completely change the scope of an entire section.
This is maybe the most important interpretive nugget for any learner. When a definition uses the word means, it's an exhaustive definition. It restricts the meaning of the term exactly. It limits the application.
So it's a closed list.
A closed list. The definition of director in the Companies Act says director means a director appointed to the board. You can't argue a general manager as a director because the definition is exhaustive. It's sealed.
And when the definition uses include,
that is an inclusive or extensive definition. It serves to enlarge the common meaning of the word. For example, the definition of debenture says it includes debenture stock, bonds, or any other instrument evidencing a debt. The common understanding of debenture still applies, but includes makes sure that stock and bonds are also covered. It extends the scope.
What about the tricky variance? What if a definition uses means and includes?
That combination means and includes is generally read as exhaustive. The means part dictates the limit. Conversely, apply to and include is understood to be extensive or inclusive. These words are chosen by drafters with incredible precision.
Following that thread, let's look at two operative words that seem similar in daily English but are radically different in law: shall and may.
In statutory language, shall raises a strong presumption of being mandatory. It's imperative. It implies a duty that must be performed. May raises a presumption of being directory or enabling. It's discretionary.
But that presumption isn't absolute. You mentioned courts can interpret them interchangeably based on context, which sounds a little unstable.
It sounds unstable, but it's a necessary tool to uphold legislative intention. The courts prioritize the purpose over the literal word. Take Section 3 of the Companies Act, which says, a company may be formed. Although it says may, the courts read this as shall because compliance is mandatory to form a company. The legislative intent is clearly imperative.
And the reverse, where shall is read as may.
That happens too. If interpreting shall literally would lead to an absurd or unjust result that contradicts the whole purpose of the statute, the courts might read it as may. The context is what matters.
Has the Supreme Court given any guidance on this?
They have. In one case, the court observed that if the legislature uses shall for one thing and may for another in the very same section, that clearly implies a distinct intention. One is an obligation, the other is discretion.
That makes sense.
But the definitive guiding principle is that the word shall is ordinarily mandatory, but sometimes it isn't, if the context or the overarching intention of the statute demands otherwise. Intent is always the final deciding factor, not just the literal word.
Now we enter the heart of the General Clauses Act itself. Section 1 is the short title, Section 2 is repealed. So we jump right to Section 3, which is this massive dictionary containing 67 defined terms.
It is, and it applies to all post-1897 central acts unless overridden. Let's walk through the most critical of these, starting with Act, Sec 3.2.
When we talk about a positive act, the GCA definition has a twist. It includes illegal omissions. What does that mean in practical terms?
It means the legal definition of an act is comprehensive. It covers both what you do and what you illegally fail to do. This concept is borrowed directly from the Indian Penal Code, the IPC. An act includes an omission that is illegal, but not one that is just careless but not against the law.
The IPC Section 36 illustration really clarifies this. Can you walk us through that specific example?
Certainly. Imagine a person, A, causes another person, Z's, death. The legally defined act that led to the death might not be a single blow. It could be a series of positive acts like blows from a beating, plus a series of illegal omissions like wrongfully refusing to give Z food.
Knowing they would die without it.
Right. The positive act and the illegal omission combine to form the legally construed act that resulted in the crime.
Next, affidavit, Sec 3.3.
This is an inclusive definition. It doesn't give a rigid definition, but says an affidavit shall include affirmation and declaration. This covers people who are legally allowed, for religious or other reasons, to affirm or declare instead of swearing a traditional oath.
Okay, so it's just a written statement confirmed under oath or affirmation for a court.
In essence, yes.
One of the most historically complex definitions is the central government.
Mm-hmm.
This one shifts dramatically based on the time period. You almost need a timeline just to interpret this one word.
It is indeed a time machine. You have to categorize it.
Yeah.
Pre-Constitution, before 1950, central government meant the Governor General and Council.
Yeah, post-Constitution.
After 1950, central government means the president, acting on the advice of the Council of Ministers or whoever the powers have been delegated to.
And it also covers provincial governments and union territories to ensure continuity.
It's very meticulous in covering that administrative continuity, yes. It makes sure actions taken during transition periods remain legally valid.
Next, defining when a law actually starts.
Yeah.
Commencement.
Yeah.
Sec 3.13.
Commencement simply means the day an act or regulation officially comes into force. This is usually the date of assent or a date specified in a notification. The key legal principle here, and this is very important for counting time, is that the law takes no cognizance of fraction of day.
So if a law starts on January 1st, it's legally enforced for the entire 24 hours of that day.
Correct.
Document Sec 3.18 seems straightforward, but its modern application must be huge, covering digital formats.
It is extremely broad and inclusive. It means any matter written, expressed, or described upon any substance, letters, figures, marks for the purpose of recording that matter. This is flexible enough to include physical books, paper files, inscriptions on metal, and critically today, electronic and computer files.
They fall under matter described upon any substance.
Precisely.
And the one famous exception,
Yes, the very specific exception is that the definition of document in the GCA does not include Indian currency notes. This ensures currency is treated as money, not just a record for legal purposes.
Let's look at two calendar definitions. Financial year, Sec 321, versus year, Sec 366.
The GCA standardizes this. The financial year means the year starting on the first day of April. It's the April 1st to March 31st standard. In contrast, the general definition of year is just a year reckoned according to the British calendar, so January to December.
One of the most fascinating definitions is good faith, Sec 322. The GCA definition is highly unusual. It can be a huge trap.
It's a profound departure from general civil law. The GCA defines good faith as honesty, specifically stating whether done negligently or not.
So it focuses purely on the subjective honesty of the person.
Yes. This is totally different from the definition in, say, the Indian Contract Act, where good faith requires due care and attention.
So if a law uses the GCA definition, a person who acts honestly but carelessly can still claim legal protection for acting in good faith. That feels counterintuitive.
It is a deliberate choice to protect honest action, even if the person wasn't prudent. But that's only unless the specific law provides its own definition. The standard for the Contract Act, for example, is higher because the GCA definition would be repugnant to the context of due diligence.
Okay, let's quickly cover two remaining property definitions. Government securities, Sec 324.
Simply put, securities of the central government or of any state government. With the historical caveat that in acts made before the Constitution, this didn't include securities of the former princely states.
And back to our Ananda Behera concept. Immovable property, Sec 326. We said it's an inclusive definition.
Yes, based on those four core elements: land, benefits arising out of land, or profit a prendre, things attached to the earth, or things permanently fastened to anything attached to the earth.
Let's make that distinction between attached things and movable goods absolutely clear.
The key is intention and permanence. Trees rooted in the earth, drawing sustenance, are immovable property. The right to take forest produce is a benefit arising out of land. Machinery fixed to the soil with the intention of staying there is immovable.
But timber isn't.
Right. Timber trees intended to be cut and transported immediately is not immovable property. The intent to sever it is the critical distinction.
A quick note on penal terms. Imprisonment, Sec 327, and offense, Sec 338.
Imprisonment is defined broadly as imprisonment of either description rigorous with hard labor or simple as defined in the IPC. This gives courts flexibility. An offense is simply any act or omission made punishable by any law.
And finally, Official Gazette, Sec 339. We keep mentioning this.
The Official Gazette is the authorized public journal. Publication here is the formal legal act. It's crucial because courts have emphasized that a notification has to be a formal announcement, not just some internal administrative instruction.
Before we move on, a final word on application via Sections 4 and 4A.
Just remember, the GCA is internally segmented. Some definitions, like immovable property, apply broadly to older acts. Others, like commencement and financial year, are a bit more restricted to acts made after January 1887. The dating ensures that older statutes aren't suddenly redefined by a concept that didn't exist when they were written.
We've established the legal dictionary. Now let's look at the instruction manual, the general rules of construction. This explains how we treat laws as they are passed, repealed, or cited. Let's start with coming into operation of enactment, Section 5.
Section 5 sets the rules for commencement. The default is simple. If the act doesn't specify a date, it comes into force on the day it gets the president's assent.
What if a specific date is prescribed later?
If the act empowers the executive to notify a commencement date, that specific date, published in the Official Gazette, governs. So a law might get assent in June, but the ministry might say it's effective October 1st. October 1st is the date.
This brings up a critical question. Can courts compel the executive to enforce a law if it's just dragging its feet? The law has been passed, but the government hasn't notified it.
This is a complex constitutional balance. The Supreme Court said in A.K. Roy v. UOI that where the government has the power to bring a law into force when it sees fit, no court can issue a mandamus, which is a compelling judicial order, to force the government's hand. The court can't dictate policy implementation.
So the executive has final discretion.
Not entirely unchecked. In another case, the court held that if a manifestly unreasonable amount of time has passed, the court can issue a writ directing the government to consider the question of commencement within a fixed time frame.
So they compel consideration, not implementation.
Exactly.
Accountability.
Before we talk about laws vanishing, a quick reminder of the anti-retroactivity principle. This is fundamental. All laws that affect substantive vested rights generally operate only prospectively. They only affect future actions. There is an extremely strong legal presumption against applying laws backwards unless the language of the act expressly and unambiguously says so.
Now, Section 6, the anti-chaos provision, effective repeal. When an old law is replaced, what's the default legal assumption?
The general legal principle is that whenever an act is repealed, it must be considered as if it had never existed. It's completely obliterated from the statute books.
But if an act is totally erased, wouldn't that destroy all actions, liabilities, and ongoing cases that happened while it was in force? That sounds like legislative anarchy.
That's the chaos Section 6 prevents. It provides 5 vital exceptions, continuity clauses, that ensure rights and obligations accrued under the repealed law survive.
Okay, what are they?
The repeal shall not: 1. Revive anything not in force previously. 2. Affect the previous operation of the repealed law. 3. Affect any accrued right, privilege, or obligation. 4. Affect any penalty already incurred. And 5. Affect any ongoing inquiry or litigation about the above.
So if I started a contract under the old law, or if I was being penalized, that process doesn't just vanish when the law is repealed.
Precisely. The repeal wipes the statute off the books for future actions. But Section 6 protects all vested rights and pending lawsuits from the time the law was operational.
You mentioned a critical distinction earlier, repeal versus deletion. Why is that so crucial?
It's a matter of retroactive effect. A repeal is an act of obliteration, wiping the provision out as if it never existed. This needs Section 6 to protect past rights. Deletion, however, usually happens through an amendment. It takes effect only from the date of the legislature's action. It does not wipe out the provision's past existence.
So Section 6 only applies to a statutory repeal, not just deleting a rule.
Correct, as was affirmed in the Kolhapur-Canishgar Works case.
If a law is repealed and the legislature changes its mind later and wants to bring it back, what does Section 7, Revival of Repealed Enactments, say?
Section 7 mandates a high bar. The intention to revive a repealed statute must be expressly stated in the new act. The law doesn't allow for implied revival. It avoids judicial guessing games.
Now for legislative efficiency. Section 8, Construction of References to Repealed Enactments. This seems like a masterstroke that prevents administrative paralysis when foundational laws change.
It's a truly beautiful piece of drafting. The rule is simple. If a provision in Act A is repealed and reenacted, and Act B references the old provision, the reference in Act B is automatically construed as a reference to the new reenacted provision.
Give us the tax example. Show us the chaos this section prevents.
The classic example is the Income Tax Act. Section 115JB required companies to calculate book profits by referencing the Old Companies Act of 1956. When the New Companies Act 2013 came into force, the Income Tax Act wasn't immediately amended.
So without Section 8, the IT department would have been in limbo.
Complete administrative limbo. They would have needed hundreds of immediate statutory amendments. Section 8 automatically ensured the reference shifted from the old 1956 Act to the new 2013 Act, allowing tax collection to proceed seamlessly.
Time computation is next. Section 9, Commencement and Termination of Time, gives us the rules for counting days.
This codifies the standard counting rule. The word from excludes the first day of the period, and the word to includes the last day of the period.
Let's use the corporate dividend example to make that concrete.
Okay, imagine a company declares a dividend on September 30th. The law requires it to be paid within 30 days from the date of declaration. Because from excludes the first day, the period runs from October 1st to October 30th. The 30th is included. That's the hard deadline.
What if that deadline falls on a holiday? Section 10, Computation and Time, Court Office Closed, provides relief.
If the last day for an action filing an appeal, submitting a document falls on a day the court or office is closed, the action is deemed done in time if it's performed on the next day the office is open. The closure automatically extends the deadline.
Section 11 is simple. Measurement of distances.
Unless the specific act says otherwise, distance must always be measured in a straight line on a horizontal plane. As the crow flies, not by the road.
Now, duty to be taken pro rata, Section 12. This is about proportional allocation in finance.
The Latin term pro rata means proportional allocation. Section 12 mandates that if a duty like customs or excise is leviable on a given quantity, then a like duty is leviable at the same rate on any greater or lesser quantity.
So this is about ensuring fairness and standardization in taxes, regardless of small variations in measurement.
Exactly. It ensures the tax burden is perfectly scalable. If the rate is 20% per kilogram, the pro rata rule ensures a 1.5 kilogram batch is taxed at 20% of the value of 1.5 kilograms. It standardizes the calculation of fractional liabilities.
Finally, Section 13, Gender and Number, the rules for linguistic flexibility.
This section handles two things. First, words importing the masculine gender are taken to include females. He includes women. Second, singular words include the plural and vice versa.
How does this apply in the real world, like with the Criminal Procedure Code?
It's profoundly practical. The CRPC makes a child liable to maintain their parents. The GCA's gender rule means the reference to his father and mother is automatically construed to include her father and mother, making a daughter equally liable.
And what about the corporate law application of singular including plural?
That's used heavily. The Companies Act says a key managerial personnel, a KMP, can't hold office in more than one company except its subsidiary company. By applying the GCA rule that singular includes plural, a KMP can hold office in more than one subsidiary company.
But again, the escape clause applies. If the context is repugnant, the rule doesn't apply.
Right. You can't use Section 13 to alter the core intent. If a law of succession defines lineage through male descendants, you can't use Section 13 to interpret that to include female descendants. That would contradict the legislative intent.
Let's move to how the GCA standardizes and clarifies the powers of administrative authorities. Starting with Section 14, power conferred to be exercisable from time to time.
This is a fundamental rule for ongoing governance. It dictates that any power granted by an act may be exercised repeatedly as occasion requires. The power is not exhausted after a single use.
Like with the States Reorganization Act.
Exactly. The power to alter boundaries could be exercised whenever the necessity arose, not just once.
Section 15 deals with appointments. Power to appoint to include power to appoint ex officio. What does appointment ex officio mean?
Ex officio literally means by virtue of one's position or office. Section 15 clarifies an appointment can be made by naming a person or by virtue of the office they hold. This is standard in government boards where the head of a department automatically sits on another board.
Section 16 is about administrative control. Power to appoint to include power to suspend or dismiss. This is a powerful implied check.
It's a critical principle of implied administrative law. If an authority has the power to make an appointment, it implicitly holds the power to suspend or dismiss that person. This power exists whether that authority made the original appointment or inherited the function.
So if a judge appoints a court receiver, they automatically have the power to remove them, even if the rules are silent on removal.
Exactly. Similarly, the Chief Justice can appoint high court staff. Section 16 ensures this power implicitly includes the power to suspend or dismiss that staff.
Sections 17, 18, and 19 deal with continuity in government. Section 17, substitution of functionaries, lets the law refer to the title, not the person.
This ensures legal stability. Laws can refer to the district collector, and that reference applies to whoever is in that job at the time. It prevents having to update legislation every time a new person takes office.
And Section 18, successors.
Same logic, but for corporate bodies or departments with perpetual succession. References in law to the Mumbai Municipal Corporation apply automatically to its successors.
And Section 19, official chiefs and subordinates.
This is about delegation. A law concerning a superior also applies to deputies lawfully performing the superior's duties. Again, it's about practical continuity.
Okay, let's talk about subordinate legislation, the rules, schemes, and notifications that form the everyday reality of law. Section 20, construction of orders, etc., ensures their meaning aligns with the main parent act.
Yes. When power is given to issue rules, the terms used in those rules must carry the exact same meaning as they do in the Parent Act. If the Main Land Acquisition Act defines collector a certain way, a rule made under that act must use collector in the same way.
And a notification has to be a formal legal thing.
It has to be a formal announcement published by authority of law. It cannot be just some internal administrative instruction or a public circular. It must be gazetted.
Section 21 establishes a powerful implied administrative power. Power to add to, amend, vary, or rescind.
This is essential for flexibility. The authority that issued a rule has the implied power to modify or rescind it. Crucially, they have to do it in the same manner as it was originally issued. This allows government to adapt regulations to changing needs without needing specific statutory permission for every minor change.
Section 22. Rules made between passing and commencement solves a specific timing challenge.
This is purely a preparatory provision. It validates rules that are drafted after an act is passed but before it officially commences. It's done to prevent delay. However, these preparatory rules can't legally take effect until the parent act itself is operational.
It just lets the administrative machinery get ready to go.
Exactly.
Section 23 dictates the procedure when rules require previous publication. This ensures public consultation.
When previous publication is required, the authority has to follow 5 mandatory steps. First, publish a draft for people likely to be affected. Second, ensure publication is sufficient. Third, a notice must specify the deadline for comments. Fourth, the authority must consider all objections or suggestions received.
And the final publication acts as conclusive proof that they did all that.
Yes. Publication of the final rule in the official gazette is considered conclusive proof that the procedure was followed. This prevents endless litigation over minor procedural lapses.
Finally, Section 24, continuation of orders under repealed reenacted laws. This reinforces the continuity we saw earlier, but for administrative orders.
This is crucial for avoiding disruption. If an act is repealed and reenacted, any existing appointments, rules, or schemes made under the old act continue in force until they are specifically superseded by the new act. The classic example is the Mines Act of 1923, which was replaced in 1952. The old rules just kept operating under the new act until new ones were made.
We wrap up with the miscellaneous sections that streamline judicial and communication standards. Section 25, recovery of fines.
This section simplifies things. It says the established procedures for levying fines as laid out in the IPC and the Code of Criminal Procedure apply universally to all fines imposed under any act, rule, or bylaw unless that specific law says otherwise. It's a standard enforcement mechanism.
Section 26 is about a core constitutional right. Offense punishable under 2 or more enactments. This is the GCA's version of the principle against double jeopardy.
This codifies the rule that no offender shall be punished twice for the same offense. Now, pay close attention to the nuance. The offender can be prosecuted and convicted under either or both laws, but the bar is only against double punishment.
So, an offender can theoretically be tried under 2 different laws for the same act, as long as the legal ingredients of the 2 offenses are distinct.
Exactly. The Supreme Court has clarified this applies only when the ingredients that constitute the 2 offenses are identical. If the same action constitutes 2 different crimes, say criminal breach of trust under the IPC and corruption under the Prevention of Corruption Act, an acquittal on one doesn't bar conviction on the other. The act might be the same, but the offense must be identical for the double punishment bar to apply.
Section 27 is highly practical, meaning of service by post, the rule of deemed service.
This establishes a crucial legal presumption. If a law requires a document to be served by post, service is deemed to have happened if 3 things are done. 1, it's properly addressed. 2, it's prepaid. And 3, it's posted by registered post. If you do that, the document is legally presumed delivered.
But there is a well-known legal trap here about the type of post used.
There is a critical detail. If the rules specifically demand service by registered post acknowledgement, due, or RPAD, then sending it by regular registered post only is not enough. It doesn't trigger the presumption of service. You have to follow the specified method strictly.
But if the recipient just refuses it?
If it's sent correctly and the recipient deliberately refuses the letter, that refusal is still deemed to be valid service.
And finally, Section 28, citation of enactments.
This just ensures simplicity. Acts can be cited by their title, short title, or their number and year, and it clarifies that when you cite a portion, say sections 10 to 15, that includes both Section 10 and Section 15.
What an elegant and comprehensive legislative tool this act is. It truly is the invisible operating system beneath all of Indian law.
To summarize, the General Clauses Act is the backbone of India's legislative consistency. It provides the standard calendar, defines basic concepts, standardizes administrative powers, and ensures continuity even when major laws are repealed. It lets the entire system run on a stable, shared language.
Here's where it gets really interesting for me. Once you understand the GCA, the technical difference between means and includes, or the contextual reading of shall versus may, reading any new law, is like having the code book unlocked.
It is.
You immediately know the base meaning of these crucial terms and the default rules without ever having to look them up. You know the ground rules.
The biggest takeaway is that legislative drafting is deliberate. Every single word choice is precise. It's designed to either follow the GCA's default setting or to actively override it. This act forces us to realize that mastering the law starts not with the headlines, but with the universal definitions and rules that govern them all.
Absolutely. And that leaves us with the final provocative thought. The legal principle that an act once repealed is treated as if it had never existed seems like a clean legal obliteration. But how does society balance that need for formal legal erasure against the persistent public memory, the history, and the behavioral conditioning that the repealed law governed for decades?
It brings up a huge question about the difference between legal continuity, which the GCA manages beautifully, and public historical obliteration, which is an infinitely harder thing to achieve.